Hi, everyone. I am Christopher Pochon. I am a partner with Levenfeld Pearlstein here in Chicago. And today I'm joined by John Young from Kingsley Napley, based in the UK. They are one of our partner firms with GGI. And we're really excited to have John on board because today we're going to discuss differences between mergers and acquisition practice in the UK versus the US. And so John's going to give us some insight as to what sort of standard market practice in the UK and some of the differences. So John, thanks so much for being here, first of all.
It's a pleasure to be here and to have the opportunity to talk to you about this, Chris. It's really interesting, and I think it can perhaps be really useful for people from the US who are thinking about investing in UK companies to understand some of the differences. It can really help smooth the process and make for a faster and less painful transaction.
Yeah, absolutely. I totally agree. And so let's just dive right into some of the differences. So one of the things that sort of can be difficult for US-based attorneys to wrap their heads around is that when we say representations and warranties in a purchase agreement, we essentially mean the same thing. There's no real difference between a representation and a warranty. But I take it that's not the case in the UK. Can you explain a little bit?
Right. Yeah, this is a really significant issue in US-UK transactions. In fact, it's probably the one that I find causes the most disruption. Because, as you said, in the US, warranties and representations are pretty much the same thing, but there are really significant differences in the UK. The practice in the UK is that sellers will warrant matters, but they won't represent it. That's because of two reasons. One is that there's a difference in the measure of damages for warranty and representation claims. Essentially, for warranty claims, you will get, as your measure of damages, losses that are in the reasonable contemplation of the parties prior to entering into the transaction. And what that broadly means is that you'll end up with something along the lines of the difference between what you paid for the business and what you would have paid had you known about the issue. So, it might be very close to the actual cost of putting the issue right, or it might be quite dissimilar because the judge might decide that actually you wouldn't have changed the price had you known about the problem. For representations, on the other hand, it's losses that were reasonably foreseeable at the time that you entered into the contract. So it's a lower bar for a loss to be within the contemplation of damages. So higher damages award overall, much more analogous to like an indemnity level of damages, cost of fixing the issue. The other thing that you get with representations in the UK is the possibility of rescinding the contract. So if the judge finds that there has been a misrepresentation, you may find that he says, and now the contract gets torn up, and the sellers get the company back and the buyers get their money back, which is often a total disaster, particularly for sellers. They've spent some of the money, they've paid tax, they bought Ferraris, whatever it might be. They're out of the business, they don't know what's going on. It's potentially been partially integrated into the buyer's business as well, so things aren't as they were. And it can rapidly become a real mess. So yeah. Practice in the UK is just to go with warranties and avoid the risk of the high damages and rescission.
I see. So the risk of rescission doesn't apply to warranties, but if there is a representation that the sellers make, then it's triggered.
It can be triggered, yeah.
Can be triggered, yeah. So if you could sort of talk to us a little bit about how that difference plays into the practice around warranty claims, and my understanding is they're a lot less common in the UK than they are in the US.
Yeah, that's certainly true. The warranty claims are very rare in the UK, which feeds into a couple of things in the process of the transactions. I'm sure all of us English lawyers would like to think that it's because we're so great at the disclosure process, but the reality is that it's primarily commercially driven. UK buyers kind of tend to take the view if they're broadly getting what they expected to get financially, then they won't normally bother to bring a warranty claim if there is an issue. where they would bother to bring a claim is if it's very big, if it really is something that would have made a big difference to what they'd have paid for the business in terms of proportion of the purchase price, or if it's a massive cost to put right, or potentially if it's something that's a serious reputational risk for their wider business. But all of those things are relatively rare, particularly if the exercise has been done properly by the sellers and their solicitors in terms of disclosure. So we don't see them very often. I mean, I've been doing M&A transactions for coming up on 25 years now, and I'm probably about to curse myself here, but I think I've seen one or two potential warranty claims in that length of practice, which were dealt with, practically speaking, between the parties rather than actually turning into a claim or even kind of serious exchanges of correspondence.
I see. So much different than the practice in the US, where particularly in large transactions, sellers just view indemnification claims as kind of the cost of doing business in a sense.
Yeah.
So that's interesting. And I take it, given the rarity of warranty claims in the UK, that the indemnification provisions in the purchase agreement are probably much less spelled out than they would be customarily in the US. Is that right?
Yes. I mean, unless it was an actual indemnity, so it was a known issue, and it was agreed that the sellers would pay pound for pound to put it right should it crystallize. So dealing with a known piece of litigation, for example, then there wouldn't normally be anything specific in the agreement at all. You would just rely on the general law and the application of the measures of damages that I mentioned earlier, rather than setting out a particular process or a particular way that losses would be determined.
Okay, understood. And when there are claims, what sorts of caps do you see on warranty claims in the UK?
Yes, this is different from the US as well. There are always caps in an SPA on warranty claims. Quite commonly, they're capped at the purchase price. We do see lower caps sometimes on transactions. It's a bit more common these days, more common on larger transactions than smaller transactions. But it's pretty unusual to see a cap at less than half of the purchase price, certainly on the kind of transactions that I deal with on a day-to-day basis.
And that's for all warranties, correct? Not just for sort of fundamental ones.
Correct. That's for all the warranties.
Okay. Yeah. So quite a bit different than the US. So I'm interested in the differences between sort of the way that exceptions to the warranties are disclosed, or just the disclosure process in general in the UK. How is that dealt with? And is there a separate disclosure schedule that the seller delivers in connection with the purchase agreement?
Yes, I think this is quite different from the US as well. So the way I understand it normally works in the US is that you have a disclosure schedule, which is part of the sale and purchase agreement itself. What we have in the UK instead is a disclosure letter, which is a separate document, which qualifies the warranties to the extent that what's disclosed hits the standard of disclosed with a big D as defined in the sale and purchase agreement. Disclosure letters divided into two parts, which is again different from the US, I think. We have the general disclosures at the front, and then we have a schedule, which is specific disclosures. Specific disclosures are the same as US disclosures. They are just specific matters disclosed against specific warranties to allow the buyer to understand what's going on. General disclosures are matters which are deemed to be incorporated into disclosure letter by reference. So often they will be things that you could discover by carrying out public searches. So you would see, for example, in almost all transactions that there's a general disclosure of matters which you could have discovered by doing an online search at our company's registry a couple of business days before completion, or doing a search at our land registry in the same kind of period. Sometimes you see that going a little bit wider to cover things like trademark registries as well. You will also see it there, which I think is very unusual in the US, typically incorporating the information in the data room into the disclosure letter by reference. So if just by looking through the data room, you could have put 2 and 2 together to understand that this document was revealing a breach of that warranty, then that could potentially qualify the warranty, protect the sellers, even if it wasn't mentioned in the specific disclosures.
Yeah, so that's very different from the US. Typically, we'd have, as you probably know, a statement in the purchase agreement specifically disclaiming any representation based on the data room, and stating that the representations and warranties of the seller are limited to what's actually in the agreement. So yeah. Quite a bit different.
We certainly wouldn't normally warrant the data room contents, but we would disclose it and say, you know, we told you about this, so it's your problem, even if we didn't remember to mention it in the disclosure letter. You do also see other general disclosures sometimes. They're less common, but you see people sometimes trying to do things like say that you're deemed to have knowledge of anything that's wrong with the properties that you would have discovered had you had a survey done, that kind of thing. But I don't generally hold with those matters because it's a bit vague, frankly. I mean, who knows what you would have discovered if you'd gone and had a wander around and looked at them as a non-expert person.
Yeah, so even if you didn't have the survey done.
Yeah, exactly.
It would still be disclosed. Okay.
So again, a little bit different, but that's less common. Personally, if I'm negotiating a disclosure letter, I try and keep it really to stuff that you can discover through searches plus the contents of the data room.
Yeah, so it sounds like in general in the UK, there's much more of a onus on the buyer to conduct a thorough due diligence process, and to closely examine everything that's been put in the data room.
Yes, yeah, very much so. It's important to make sure that you've kind of had a proper look at everything.
Yeah. So let's talk about the indemnification process in general. To the extent that you know, there are warranties in the agreement, what type of survival periods do you see for these warranties?
For tax warranties and under the tax covenant, there is a market standard position, which is 7 years, which is never negotiated, and which I think isn't too dissimilar to the typical US kind of 6 years plus 60 days. For tax warranties and indemnities, so for non-tax warranties and indemnities, it's more negotiated. The kind of rough rule of thumb that you would expect to see is somewhere in the region of 1 complete accounting period plus 6 months to allow accounts to be prepared, but you do see variations on that to either side. So usually it's somewhere between kind of 18 months and 3 years. For that, probably edging more towards between kind of 18 and 24 months, depending on how the accounting periods fall. There is an exception to that, which is fundamental warranties. In the UK, we don't always draw a distinction between fundamental warranties and other non-tax warranties, although it's becoming more common in practice at the moment, I think perhaps under US influence. But for those, you would often see a limit, which is more like 12 years from the claim arising, which is connected to the maximum period of time that a claim can be brought under UK law for a deed.
I see. Sort of general statute of limitations.
Yeah.
Okay. And what about sort of deductibles versus tipping baskets? What do you commonly see in the UK?
So there will inevitably be in the UK limitations at the bottom end by way of a basket for claims, so an aggregate amount of claims which need to potentially be brought before you have to pay out as the seller. That market practice for that is it's typically around 1% of the purchase price. If it's a very small transaction, then you might find that it's a bit more than 1%, just because it's not worth the trouble of bringing a warranty claim and all of the costs. You wouldn't normally see a basket which is less than kind of £25,000-30,000. Just because who's going to bother litigating if you've only lost £25,000 or £30,000 on a warranty breach? It's just not worth the trouble. Sure. That is usually a tipping basket in the UK. So once you've gone through that limit, everything is fair game, even the items which got you to the figure in the first place. What would often be excluded from that is de minimis claims. So we would normally say that if you have a small claim or series of connected claims which are small, you just get disregarded. They just get disregarded to stop to stop buyers like aggregating lots of small claims to just get themselves over the limit, and then they can bring claims for everything. The size of that varies on the transaction. It's typically not not less than about £500 for a de minimis. And typically, I don't often see it being much more than £10,000, although for a very large transaction it might be. So I think probably the range of somewhere between about £2,500 and £5,000 is a relatively typical de minimis for the kind of transactions that I see.
I see. Yeah. So not dissimilar to the US, perhaps a little bit smaller de minimis amount, but that, as you say, varies depending on the size of the transaction. Now, so when there is a claim, or just for purposes of sort of settling and truing up the purchase price post-closing, in the US, it's very common for the buyer to require that a portion of the purchase price be held back in escrow. But I understand that escrows are fairly uncommon in the UK. So how do you go about making sure there is actually money there for covering indemnification claims or purchase price adjustments?
Sure. I mean, that is a real issue for us. We used to have escrows in particular for potential claims quite often back when I was starting out, but regulatory changes over the last 5 or 10 years in our anti-money laundering rules mean that it's actually really difficult to get an escrow account open. In fact, it's pretty much impossible to get an escrow account open these days, because the banks just won't let you, and the regulation in terms of what we have to provide from an accounting perspective is too onerous. So it's been quite a few years since I've actually seen an escrow on a transaction which has a UK target. The typical practice instead, when you're looking at claims, is for there to be some form of deferred consideration, which you might have commercially anyway. But even if not, then there will be a bit of the consideration which is held back for the warranty period, so that you can have some kind of set off should that be necessary. In terms of providing comfort to the sellers, they're usually, if it's for a completion accounts mechanism or something like that, there normally isn't much particular comfort beyond just getting comfortable that proper financing is in place. Money isn't normally parked in a solicitor's client account or in an escrow account. It's more that commercial reliance and the knowledge that if the worst comes to the worst, well, at least there's a valuable asset in your company which the buyer has if you need to sue them. When it comes to longer term security for a seller, if there's earnouts and that kind of thing, you do sometimes see structures which involve, charges over the shares in the company that's been sold, charges in over the assets of the sold group, but it's generally
charges meaning like liens, basically.
Yeah. But yeah, fixed charge security like a mortgage. Yep. But you would not normally see that in for a completion adjustment, because it's considered generally just too much hassle, I think, to put and cost to put it in place for something that should kind of come out in the wash over the next couple of months, and where given it's an adjustment to the price, the company should have the assets, the cash anyway. So yeah, it's relatively rare to see security in those circumstances.
Understood. So, switching gears for a second, one of the big changes in US M&A over the past 10 or 15 years has been the rapid expansion of representation and warranty insurance. And I take it in the UK that it's becoming increasingly common as well. But there are some significant differences between the types of policies that you see in the UK versus the US. So can you maybe sort of explain what's customary there?
Yeah, absolutely. Warranty and indemnity insurance has been around in the UK for 20 years or so. That's probably when I first saw it on a transaction. Historically, it was most common in property SPV transactions, where you're effectively acquiring a company in a wrapper, where there were overseas owners for tax reasons, or there was just structure meant there were trustees involved, so you couldn't really get comfort as to what would happen with the money you were handing over, and that there'd be something to recover against. if there was a breach. That said, it's becoming more common in general commercial company transactions, particularly where there's private equity involved or something like that, because again, they don't want to run the risk of having to give some money back. In pricing terms, I think probably because of differences in the practice around warranty claims, it's perhaps a bit cheaper than in the US, a bit more cost effective, I should say. Typically, we'd expect to see a premium of somewhere between 0.75% and 1% of the sum written. Although you do have to add to that insurance premium tax, because we do like to have lots of different taxes on things. So there's a tax which is 12% of the premium. There's also a minimum price in practice, which tends to be about £30,000 or £40,000, just to make it worth the insurer's while going through the process. So that's interesting. The policies that we've seen historically tend to be policies which are written on a specific set of warranties that have been negotiated, perhaps with some qualifications or adjustments where the insurers didn't like specific risks. But they've recently started with synthetic warranty and indemnity insurance, which is quite an interesting concept. So if you're planning to buy a lot of companies in the UK in a particular market, go on a real kind of buy and build campaign, then you can agree a standard set of warranties with an insurer, and they will just stamp them out for you on every transaction.
And that's regardless of sort of the individual purchase agreements that you negotiate with X, Y, and Z companies.
Yeah, correct. Which means you don't even necessarily need to negotiate warranties and tax indemnity at all, because it's already dealt with your insurers.
That's very interesting. And how do they? I mean, how does the insurer go about making sure that you've done due diligence in that case, given that they're they may not even know which companies you're planning to buy?
There will be a little bit of a chat about due diligence and making sure that you are doing something to take a look at it, but it's not like they'll do the full-on exercise where they would require you to hand over the due diligence report. They just want comfort that you're sensible, and then they take a risk based on the kind of general market practice that warranty claims aren't that common, and gives you the spreading of risk across a number of transactions. So it's quite an innovative model, which I'm looking forward to having the opportunity to work on a couple of deals with, because it brings the real possibility of being able to sell as a buyer that you can move much faster on a transaction, because you don't have to spend all that time negotiating warranties, which are a big part of the deal documentation. So yeah, it's an interesting prospect. In terms of who pays for these things, because the policies are non-recourse for the sellers normally, so the sellers know that they can walk away and not have to worry about handing any money back. They're written in the name of the buyer, so the buyer will pay the insurance premium. The commercial reality, of course, is that insurance premium comes off the price, so the net position is that it's covered by the seller.
Yeah, so it's basically factored into the purchase price. As a deduction.
Yeah.
Okay. Yeah. So similar to practice in the US, I think, although sometimes it's negotiated whether buyer or seller will bear the burden of paying for the cost of the RWI. Now, when you say the policy is non-recourse to sellers, typically, at least in US policies, there would be a waiver of subrogation rights. The insurer would waive subrogation rights, except in the case of fraud committed by one of the sellers. Is that similar in the UK?
Yeah, exactly. That's the position here as well.
Yeah. Okay. And what are the deductibles or what we call retention amounts in the US? What do you typically see in a UK transaction for a policy?
We tend to call them excesses. Lots of different terms for the same thing. The excess is normally in the region of what you would expect to see for a warranty claims basket, so roughly 1% of the purchase price, there or thereabouts. And sometimes those are tipping deductibles as well. Sometimes they're not, but you do see it positioned so that you are effectively recreating the cover that you would have had under the SPA.
I see. So I'm interested to hear how in a UK transaction you'll handle warranties that are qualified by knowledge of the sellers. and what you typically see there? Is it sort of a broad group of people? Do they have a duty to make inquiries? What's market practice there?
So the typical position for awareness-based warranties is that they would be given by all of the sellers. So it would be, so far as the sellers are aware, would be what we write in, and that would mean all of them. The sellers may be deemed to have knowledge of some other people sometimes, for these purposes, to encourage them to go and talk to appropriate people who may know things that they don't. So if there is a management team who are running the business day to day, you will often find that those people are on the list that they should have made inquiry of. Occasionally you will see external advisors, so you might perhaps see the accountants in relation to accounting or tax matters. Rarer to see the business's lawyers' knowledge being captured here. Normally it's really the sellers and the people who are managing the business on a day-to-day basis who you'd want to speak to. And sometimes if you have you might have particular issues, like say employment issues, where you would have to consult on the head of human resources for that issue, but you would not have to consult with that person for accounting issues, say, or tax issues, because it's just not going to be relevant. So there's no point making them sit down and read accounting and tax warranties when they could be spending their time more productively.
That makes sense. So that's seller knowledge. Now, one of the issues of sort of the converse of that is when the buyer has a knowledge of a breach of one of the seller reps and warranties. In the US, typically that's referred to as sandbagging, where a buyer knows about a breach, closes the transaction over it, and then brings a claim based on that breach. And that, it obviously depends on the jurisdiction in the US and what it says in the purchase agreement, whether that's allowed or not. But what's the general sort of baseline rule in the UK, and are there exceptions to that?
So the general baseline rule is that the knowledge of the buyer can qualify the warranties, so that they can't bring a claim about something they knew about, even though it wasn't in the disclosure letter. Either was a specific or a general disclosure. There was some case law that cast the net quite widely in terms of what the knowledge of the buyer was deemed to be. And so market practice in the UK these days is that the knowledge of the buyer that will qualify the warranties will be defined. And you will occasionally find that a buyer will try to say, oh, if it isn't in the disclosure letter, then it doesn't qualify the warranties, but that isn't a normal position. Typically what you will find is that something which is in the actual knowledge of the buyer's deal team, and perhaps also its directors, will be deemed to protect the sellers, even if it isn't properly disclosed. Anything that, minor members of the deal team know, anything that people in the commercial business just happen to know because, it's a trade sale and they've worked together or they've heard some gossip, wouldn't typically disqualify the buyer from bringing a claim.
I see. Well, thank you so much. This has been really interesting and really helpful, I think, to potentially, U.S. clients who are thinking about doing a deal in the U.K. Or expanding their business there. Certainly, you've given us a lot of food for thought on the differences in UK transactions. So thank you for your time, and I really appreciate it. And if you have any questions, obviously, if you're watching this online, you can reach out to either John or me, and we'd be happy to discuss further with you.
Thanks very much for having me, Chris. It's been a real pleasure.